Hello, this is Matt on the Moon Lambeau channel. In this video, I'm going to share with you some of the very latest comments from attorney John Deaton on the SEC versus Ripple case. He stated, and I'll get to the reason why a little bit later in the video, but he stated that Judge Torres may not end up ruling on Ripple's fair notice defense. Now, mind you, of course, she already said that Ripple may argue the fair notice defense as their fourth affirmative defense, I think it was, if memory serves. It's one of their defenses anyway. They're allowed to argue it. The judge determined, yes, you absolutely can argue it, but the judge might not end up ruling on it. So says attorney John Deaton. Also, he shared some comments where he pointed out, quote, "The SEC made several huge mistakes in this case," end quote, and I'm going to share with you what they are. And interestingly enough, this is the only place where you can get those comments because Twitter isn't showing you those comments. I'll explain what I mean in just a hot second here. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because if anything I say are right, I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So what got this all kicked off? Well, there was a tweet from my fellow XRP YouTuber, the Digital Asset Investor, who wrote the following. Friday reminder. The SEC is being sued by 66,000 plus XRP holders that it claims to be suing Ripple to protect. What has happened to the United States of America? And indeed, the point is never lost on me. It's completely absurd that they're, quote unquote, protecting us. If you're protecting us, why are so many of us furious over this alleged protection? It's completely absurd, and I love it, though. This is one of the best things I think that could happen to the SEC versus Ripple case, John Deaton jumping in and putting this all together, because it paints a crystal clear picture for both Judge Netburn and Judge Torres that something's not right here. This is not normal. This has never happened in the history of the SEC. I kid you not. There's never been an instance where the SEC sues somebody for doing something that was allegedly illegal that they weren't supposed to do, and then tens of thousands of people come rally together and ask to be sued so that they can have a say in this. That has never happened before. It's astonishing. And so anyway, attorney John Deaton responded to that, and he wrote the following. The SEC objected to XRP holders even being heard by the court. If the lawsuit was filed by the SEC for the benefit of XRP holders, why wouldn't the SEC want the court to hear our perspective and concerns? Unless, of course, the lawsuit wasn't filed for us. Ding, 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 exactly. And that's another thing that the judges can see through very clearly. And then there was an XRP community member that responded to John Deaton named Crypto Duke, and he wrote the following. John, I believe the SEC screwed up big time by initially taking the position that the speech was not official guidance. I'll just pause to note what he's referencing there, of course, is William Hindman's, former director William Hindman's Ethereum free pass speech, which of course he gave on June 14th of 2018. He says again, I believe SEC screwed up big time by initially taking the position that the speech was not official guidance. Not only did it open up the 63 emails for discovery, but if the speech was not guidance, what was? So their position helps the fair notice defense. Agree? Question mark. And so that's a legitimate point, which I've brought up many times indeed. Had the SEC said, yeah, this is an official position, these emails, which we really, really want, because it would ruin their case in all likelihood, or at least if they don't hand them over, result in settlement. So we're actually kind of happy in a way that this is how it went down. But had they argued that this was official decree, they still would have had a problem. If they said that the Billy Boy Hindman Ethereum free pass speech was official guidance, well, then then what would Ripple's team do? Their legal team would say, okay, well, if that's the metric we're going by, here's why, from a technical perspective, XRP is even more decentralized than Ethereum, which means that there is not a common enterprise. Bam, case closed. So either way, they're stuck. So it's like, what's the lesser of two evils? Like, they never should have brought this case against Ripple, but they're a bunch of idiot asshats, and so like, it is what it is, you know? And so that tweet that I just shared with you from Crypto Duke ended up getting retweeted by John Deaton, and he shared his thoughts in a thread. And the thread's on your screen. You notice anything funny about this? It says, this tweet is not available. Then the next tweet he wrote, this tweet is not available. And then the next one, this tweet is not available. And then it gets to this one, and this one you actually can read. So what's going on here? Well, some people think that Attorney John Deaton is being censored by Twitter. That's not where my brain went immediately, because I'll tell you what, if Twitter doesn't want you on their platform, they are not afraid to suspend people, which means that the account's terminated. It's a kind way for saying your account is terminated forever. If your account is suspended, it's a softer word, but it means your account is terminated forever. They will do that to anyone without explanation, and they do not care. So they're not going to go jump through hoops to make it look like we still want him here, but we're just going to censor him. No. I mean, there's such a thing as shadow banning. I'm not pretending that's not real, but they've never done this. I think this is a technical glitch, to be honest with you. Some people think differently. I don't know for sure. I could be wrong. I think it's just a technical glitch. That's where my brain went first, because if they didn't want him to be seen, shadow ban is a much less obvious way to go about it. This is very obvious. So shadow ban would have been the route, or just outright getting rid of him. So I don't think that's the case. I don't think Twitter really cares about this case, to be honest with you. They care about all sorts of political stuff. This, though, I don't think they have a dog in this fight, to be honest with you. So it'd be weird if they wanted to censor him on top of all of that. But still, it's annoying, because John Deaton, serving the community, sharing his thoughts, taking the time to share his thoughts from a very unique perspective, and then we can't read them. So that was annoying. And I put out tweets, and I wrote the following, actually. I wrote to John Deaton. I said, Twitter is broken again, and your thread is not viewable. This seems to keep happening. So I'll just pause to note, this is the second time, at least, that I've noticed this on John Deaton's account in a separate thread. And then I wrote, if I go to your page, I can see the first tweet, but the only way to see the second tweet is to click show this thread, but the problem is it won't show the thread when you do that. So here, I took a screen grab to show him what I'm talking about. If you went to his page, I don't know if it's changed since then, maybe it's even worse and you can't see this either. But at the time, there is this thread, so you click on where I'm circling right now, show this thread for those of you that are not familiar with Twitter, and then it'll unroll everything, and you can just see everything that I wrote. But when you clicked on that, all it said is, this tweet's unavailable, or whatever the wording was. This tweet is unavailable. That's all it would show you. So I was like, okay, well, that stinks. And so Crypto Law, John Deaton's organization, wrote, this is unlikely to be censorship, but more likely an annoying automatic and momentary suspension because of multiple threads close together. John is working on resolving it now. It has happened before. I'd say to that, maybe. I don't even think it's a momentary suspension, though. This has also happened to my fellow XRP YouTuber, the Blockchain Backer, and he's not writing all sorts of lengthy threads or anything like that. So I think it's a glitch, to be honest with you. I don't know. Could be wrong. That's just my personal opinion on that. Now, thankfully, some random dude took a screen grab of what he had to say, so I can share it with you. And by the way, when I say some random dude, I'm not just calling a person some random dude. That's his name on Twitter. You can see in the top right here. That's his name. He goes by the name Some Random Dude. So there we go. But thanks to that, and thank you, shout out to Some Random Dude. Thanks to this, I can share with you what he said. He said, so again, John Deaton retweeted what Crypto Duke had to say and wrote the following. The SEC made several huge mistakes in this case. Number one, didn't limit the allegations to specific transfers of XRP during specific years, i.e. 2013 to 2017. So I'll just pause. So pause this to say, okay, why does that matter? Well, because it would be much easier to state that there was, the factors, the four Howey factors were met, including the just overall the scheme of things, all four prongs being met. This is an investment contract. Much easier to do that if you're not talking about the same XRP, because think about this. Back in 2013, and again, I'm not saying that the SEC would win on this front. I'm just saying it would be easier for them because the XRP ledger unquestionably was not as decentralized as it is today. And that's important because that goes to one of the prongs, a crucial prong, the idea of whether or not there's a common enterprise. So by going from 2013 on up until the point of when they filed that lawsuit, much harder to make that point, much harder to make that argument. So they would have had much greater odds of success had they just been more narrow, but they're just so overly zealous about this and so arrogant. They think they can just do whatever they want, and it's crippling them. So that's why John Deaton's labeled that as a huge mistake by the SEC in this case. Number two, that mistake forced them to allege the token itself is a security per se, which, in essence, attacked individual XRP holders. Yeah, so pause. Why does that matter? Because we're all here now. Now there's over 66,000 XRP holders like, I'm sorry, what it is you said, bitch? And now we're all coming at them, and Judge Torres allowed John Deaton to represent them within this case. That's astonishing, amazing, and I'm so thankful for that, by the way. I do think, to this point anyway, we have lucked out with the judges that we have on this case, frankly. Number three. suing Brad Garlinghouse and Chris Larson individually, even though fraud or misrepresentation isn't alleged, forcing the SEC to meet a much higher burden of proof to establish the executives were reckless in not knowing XRP was a security, despite the SEC itself not knowing. Yeah, I've talked about that ad nauseum, and I'm thankful for that as well. I mean, I'm not happy that Brad and Chris have to go through that. Don't get me wrong. I'm just saying, what I'm saying is, since they did that, I'm happy that it's damaging their case, to be precise on that. And then number 4, check this out. Worried about Ripple's fair notice defense, the SEC tried to be cute and called Hinman's speech his personal opinion only, which waived any invocation of the deliberative process privilege. Why were these rookie and glaring prosecutorial mistakes made by such smart lawyers? Haven't I said this so many times in so many words? It's like amateur hour here over at the SEC, like, do you even lawyer, brah? Because I'm not sure you lawyer, brah. Not looking so hot. And I'm glad that the clowns that they've got representing the SEC, I wouldn't have it any other way. They're not doing well. They speak out of both sides of their mouth. They contradict themselves. Judge Netburn just called them out the other day. It's just fantastic. I mean, it's really a sight to behold. So for all of you that have been following along, you know, but it truly is astonishing. And I'm sorry for the rest of the world that isn't in this and doesn't know exactly what they're missing. The level of absurdity is truly impressive here. Now, there's a tweet by my fellow XRP community member and yours, Stefan Huber, and part of what he wrote was that he was just making some predictions. And the 5th one is the one that I wanted to highlight because he's in his tweet there, which is on your screen. You can read them all if you just want to pause, but I'm just reading number 5. He was saying, Hinman's emails will become undiscoverable and sealed forever. And so what we're talking about is the 63 emails related to the Ethereum Free Pass speech and the 68 drafts of the speech. And so he thinks that those are going to be undiscoverable and sealed forever. And I will say this, I personally don't think that we're ever going to see those, but here's what attorney John Deaton had to say about this. On that point, he said, I can assure you that I will do everything in my power to unseal those emails and comments. It won't be easy and I may not win, but there's no way I let it go. Now, that much I believe, for sure. He's going to. We'll see what happens. But I just have this feeling that they're going to refuse. I think they'd give up the case before they hand him over. That's the reason I'm saying I know John Deaton's going to fight. He's got some fight in him, that's for sure. I'm just saying I think that the SEC is going to be like, nope, sorry, oops, we're just going to drop this. But via settlement. I don't think they're going to do a dismissal, but that's what I'm anticipating. And now check out this from attorney John Deaton. Understandably, most people are focused on the fair notice defense, but it's possible, if not likely, fair notice defense never gets ruled on. Ripple and XRP holders can win on a strict Howey analysis. If that happens, Judge Torres could say there's no need to rule on fair notice. So folks, think about this. And John Deaton's so right. And this is why I'm so optimistic for this case. Think about this. So they could rule, Ripple could win purely on the Howey analysis. Because if you think about it just from a technical perspective, is the XRP ledger decentralized? Yes. Okay, well then today there can't be a common enterprise. Case closed on that front, right? And there'd be a lot of intricacies that would be discussed. I'm not pretending that it's literally that simple. You go through all the prongs, there'll be back and forth, fine. But the point is, Ripple wins on that. That's not a winnable position for the SEC. So that's one way they could win. Now, even if they do go through the fair notice defense, it's very clear that there's tons of confusion within the market. It's easy to show that Billy Boy Hinman was providing his speech as market guidance, all of these things. But that just added confusion, frankly, because it wasn't quite clear enough, even if that is ruled to be market guidance. But which, it's not going to be because the judge already said it's personal opinion. But even on that, Ripple can still win on fair notice. But even if that doesn't work, there's another way. Simply because of the Billy Boy Hinman emails, settlement, like flatly stated, settlement's going to come as a because I don't think they're going to hand them over. So there's 3 things right there. So maybe we never see the emails. Maybe we never get a ruling on fair notice. Maybe it's because of Howey. Or maybe it is because of fair notice. I mean, it could be any of the 3. And maybe there are other ways that this could unfold that this isn't meant to be an exhaustive list, but those are 3 big ones, right? Where it could unfold. It's just interesting. I'm just saying, no matter how you look at this, the SEC's in some serious trouble. My gosh, I don't even know how they sleep at night, frankly. And I'm not even talking because of the unethical stuff. They should be sweating bullets every single night, these freaking asshats. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.